scheduled for April 18, 2011. We'll call the meeting to order. The first item on our agenda is the approval of the agenda for today's meeting, and we do have one change that you may be aware of. The minutes have not been distributed from our prior meeting, that is the meeting on April 4th, and so we won't be able to approve those minutes today. So if you would, strike that from your agenda, and I need a motion to approve the agenda as amended.
So move.
Okay, we have a motion.
As amended.
Thank you, sir. Second?
I'll second.
Okay, Mr. Kessel seconds. Any further discussion regarding today's agenda? Any additions thereto or further deletions? Okay, hearing none, all in favor signify by saying aye.
Aye.
All opposed, no. Motion carries. All right, the next item on our agenda is Carole Hall Subdivision. That's tax lot pin numbers 9624-01-7557, also known as 146 Rustic Trail. Pin numbers 9624019590, also known as 145 Rustic Trail. Pin number 9624017363, also known as 140 Rustic Trail. Pin number 9624019252, also known as 137 Rustic Trail. And finally, 9624009816, known as Rustic Trail. Ms. Hall has requested a variance from certain sections of our land development subdivision ordinance, and those variances are related to access road width that leads into her property, and the requirement under the existing ordinance for turnouts, I think at intervals of 200 feet. Staff, if you would, please present first and tell us a little bit more about this.
Yes, sir. This is a request to bring a minor subdivision into conformance. What happened was in '06, they brought in a plat for special. Was approved as a special subdivision. Then back in '08, another plat as a special subdivision was brought in. We did not catch that it brought the subdivision up to 4 lots at that time. When they applied for a 5th lot, we realized that they had already created 4 lots and that it was needing to be brought up to minor subdivision standards. And that was in February of 2008. Within the subdivision itself, they have built the road to ordinance standards, but they do need variances for the access road in order to be approved. One is the right-of-way is 14 feet rather than the 15 feet that was required at that time in '08. The other is for the access road. It would require 2 turnouts because the access road's about 575 feet long, and the ordinance requires a turnout every 200 feet. And they just simply don't have the room to build those turnouts. The road, the access road is wide enough for 2 cars to pass, and the fire marshal has approved their plans.
Okay. All right, is there anyone here on behalf of Ms. Hall that would like to come forward and speak?
If I may, Mr. Chairman, I'm Ron Speed. I'm an attorney from Black Mountain, North Carolina.
Yes, sir.
I've been asked for Ms. Hall to assist in this presentation. I believe your files can
Go ahead and have a seat if you'd like.
your files contain all of the information that you need to see. This was an inadvertent error. At this point, we have 4 parcels showing, I think, on the map that's provided to you. I don't know the how it's numbered, but there's one parcel that takes it into makes a minor subdivision. This was an oversight, both from surveying and from Ms. Hall and the county, with a partial plat, obviously didn't reference back and missed it. And this was not an intention to try to bypass the subdivision ordinance. However, we ended up with that odd lot, that fourth lot that is useless territory right now. As staff testified, there's a stretch of road possibly identified on your survey as Greenleaf Road. That road is, the easement width on that is 14 feet. When they originally appeared asking for these variances, the board approved the width if there were 2 turnouts. We were unable to talk to the neighbors and obtain additional room for turnouts. The original variance for the width of the road expired. That had been granted once. That road on paper looks tremendously long. It's 575 feet, but as this board knows, that's less than the length of 2 football fields. And even eyes as old as mine can see one end to the other, and it's a fairly straight shot. If there were something coming down the road that you had to make room to pass, you can see it pulling into that road, hitting at the other end. The second is, and I believe Ms. Hall submitted with her application a 2-page summary of our arguments as to why we comply with the requirements for variance, but stated in there, and from the fire marshal's information and from staff's own investigation and report, I think stated to staff, the actual road bed in existence there is, I don't know, there are different words for it, but is expanded through use over time, and there's enough room for 2 cars to pass. There's really no need for the turnouts if 2 vehicles can pass, and the fire marshal, the fire chief, is comfortable that his fire truck can pass anybody on that road. It's not what we would like to be coming to this board for. Typically, we would like to come straight at you with a minor subdivision. We found ourselves having backed into this one inadvertently, and we're asking the board to grant a variance as to those 2 sections, one that's been granted before concerning the width of the right-of-way, and the second grant a relief from the requirement there be a turnout every 200 feet. Again, you can see from one end to the other an existing road bed, in fact, is wide enough to carry 2-way traffic if it's necessary. I can have, except for the fact all this seems to have been in the staff report already, I can have folks come up and testify to those same things all over again, but we're not disputing anything staff has said.
Mm-hmm. Okay. Ms. Hall, did you have something you wanted to pass out to us?
I have pictures of Greenleaf Road, and at some point that, I guess the board had pictures taken, it's over 18 feet wide, and that's the whole length of the road, and you can see all the way up to Rustic Trail. And we didn't want to come before you until we got the fire marshal's approval. Yeah, it's your pictures.
And if you don't mind, when you sit back down, I know who you are, but identify yourself for the record,
Carole
please.
Hall.
Okay.
And then these pictures, at some points, the road's 22 feet wide, and the fire marshal is in agreement that he could the fire trucks could pass.
Okay.
And there were even a couple driveways he could utilize if he needed to.
Okay. Is there anything else that you want to present to us?
None, Your Honor. Or, Your Honor, excuse me, been in court too long, Mr. Chairman.
I am honored.
Don't make his head any larger.
Yeah. Mr. Frew is smirking, but I'm honored.
I won't be able to live with him now.
As I stated, in the attachment to the application, we have stated our arguments for how the requirements of the current subdivision ordinance is met. That obviously a little strict or little interpretation at this point is going to create a useless piece of land. We're just trying to get this in compliance. We're not asking for a minor subdivision larger than 4 parcels, just trying to put this piece back in action.
Okay.
Again, the cause of that was inadvertent. Nobody was out trying to pull one on the county. I'm sure the county staff didn't intend to have this oversight, but it's happened. I guess the question to be answered is, why don't you just sell this to one of the adjoining lot owners and be done with it? Well, that's a tricky situation. Adjoining lot owners under the present condition know that we can't do anything with it, and why should they pay taxes on it when it will remain vacant? It's really has no value. Even the adjoining property owners won't make an offer on it. Granting the variance will not be detrimental to public health, safety, or welfare. I believe with the fire marshal's investigation and the description of the width of the actual physical road, the clear line of sight from one end to the other of that stretch of road indicates that there's no risk to safety or welfare. And granting the variance would support the general objectives contained within the land development subdivision ordinance. The purpose is to provide for the orderly growth in a manner and under conditions to facilitate adequate provision of streets, water, sewage disposal, and other considerations. At this point, the only consideration left is to get access in compliance with the subdivision ordinance to let this fourth lot be usable. I think although we're having to request a variance, everything else has been done as testified by staff within the subdivision itself to comply with the requirements.
Okay, thank you. Does the board have any questions of Mr. Sneed or Ms. Hall?
Yeah, I've got one. So the lot's unusable without the variance, but with the variance it is usable.
It's a buildable lot if we have legal access, correct.
I have a couple of questions, please. Debbie, you mentioned the last plan was 08, and I've got one here. Maybe you meant to say 09, February of 09.
No.
Huh? I've got one right here that's stamped Buncombe County received February 20, 2009, and this was the last time it came before the board.
I believe no action was taken on that one is the reason that.
Okay.
Okay.
Is that what
Right.
it is?
Right.
Okay.
08 was when they recorded that fourth lot.
Okay. On this plan, you had 5 lots.
You have an older version, I hope. If I may approach, I can show you we're asking for a single
It looks
lot.
like
Yeah,
you
please
just
do.
joined 2 together. Looks like this was 2 lots at one time,
Correct.
and those were joined together.
Right.
Okay.
We've eliminated and even my brief, it sounds like 2 lots, but in fact, it's one lot.
Right.
Are you looking at lot 3 there?
3.
Their request was to subdivide that into and to make an additional lot, but that was not approved.
Right.
So it's just-
What I
That has
remember
been-
there
After
was a-
discussion with staff and Mrs. Hall, she decided to try to bring the subdivision into compliance and not subdivide into that 5th lot.
No. As I remember, there was some issue with septic tanks or something on that particular lot. On this old map, such as it is, shows another driveway, and I notice on this one that driveway is not there.
That one,
It does exist, though.
It's a gravel road.
Yes,
Okay,
it's a driveway.
so it's still there.
Yes,
Okay, it's just not showing on this
it's
chart.
just not showing there.
Okay, great.
And that leads to, Reeves property.
Okay, good. Reeves, yeah,
Yes.
that makes sense. Yeah. I just want to clarify from the fire marshal's standpoint, if I remember the last time this was here, and in previous times when we've listened to the fire marshal, he's made a real big issue out of the width of the trucks, in particular with the mirrors out to the side and the requirements to pass. And now the fire marshal, you know, we were dealing with 10-foot wide vehicles, and this is not for you guys, it's more for the staff and for us, but he made real strong points about this and other previous subdivision plans, that unless you had a pullout or unless you had a one-way design subdivision road, that he needed that space for 2 10-foot wide trucks to pass. And I'm just interested, I guess he's had a little different reflection on this now.
Well, it's not his ideal situation,
Yeah.
but given the width of it in some locations at least where they could pass, plus the existing driveways where if there was need, those could be used as pullouts. he was okay with it.
So if my memory served me correctly, before he wanted to see the pullouts on this one. Not true?
No.
He's never required that?
No, sir.
Okay,
He
good.
signed off on the plans in '06.
Yeah.
There's
You
a
made
letter
sure
in
that
there.
he was
Yeah.
okay
Yeah.
with it.
Yeah, I've read the letter. But I'm just going back to the original.
No, he's always been
process.
okay with it.
Okay,
And I talked to him this morning, too.
yeah. But an issue for you has been that the owners of the other properties didn't want to allow
Additional road.
their driveways for pullouts, if you will.
Correct.
Okay. So he's comfortable, and if he's comfortable, I'm comfortable, but I just think it's interesting that he's held our feet to the fire on other subdivisions, but he's yielding for you, and I'm not saying that's a bad decision.
Size of the subdivision as
Yeah.
well. I mean, when. I've
Number of
heard-
homes, and, yeah,
Exactly.
Yeah.
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 And this is flat land, or
Yeah,
this road is flat.
looks like you could
Flat.
cut
Yeah.
out on it if you had to.
Yeah.
Yeah, I've been up there. It's been the last time you came before us, and yeah, it's relatively flat and wide.
Right.
Can I ask him, we have already recorded this extra lot, right? And if I remember correctly, the old ordinance, you could have up to 4 and not have to be a minor. Is that correct?
No, 4 was a minor. It was
4 was
up
the
to
minor.
3 as a special.
Okay, it was 3 and you could do like an extra lot. I remember at one point, there was some, maybe if it was a 10-acre lot is what I'm thinking. And then that wasn't part of it at one point. So I just wanted to check. Thanks.
Okay. Anybody else have any questions for the applicant? Okay. Is there anyone here representing the neighborhood or whatever that wanted to speak regarding this matter, either in support of it or in opposition of it? I hear none.
The planning board, Mrs. Hall did send out notices to all the adjoining property owners.
Okay, good. Good. Okay, well, having heard neither support nor opposition, I would ask the board to consider making a motion one way or another.
Mr. Chairman?
Yes.
And we would ask that you have a separate vote on each variance request.
Okay.
And you've been provided with some
And that was
possible
the reason
findings
we-
of fact.
Yeah, I got you. And that's the reason we were provided with 2.
Yes, sir.
I wondered. Okay. Okay. Would anyone entertain a motion? Making a motion?
I'll do it.
Okay, thanks, Joe.
Mr. Chair, let's see, let me make sure I got the right one here. Okay. Are these different?
Yeah, look at
Yeah,
subparagraph,
the ones for the right of way
subparagraph
and-
2,
Oh,
Joe.
yeah, okay.
Yeah.
Okay.
Under the turnouts.
Yeah. Mr. Chair, based on the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted development plan, the findings of fact worksheet, I move that this board adopt the following findings of fact, and this is subparagraphs 1, 2, and 3, dealing with the road and design standards, and more specifically requires a 15-foot right-of-way for the access to the road. And that this application does meet the requirements for granting a variance by demonstrating an unnecessary hardship on the owner for the following reasons as discussed in subparagraphs A, B, and C. I so move.
And I would ask that you also include as part of your initial findings of fact the presentation by Mr. Sneed and Ms. Hall. That's just why we spoon feed with the spaces there.
moved.
Okay, we have a motion. I think,
Second.
Rod, did you second?
Second.
Okay, any further discussion? All in favor signify by saying aye.
Aye.
Aye. All opposed, no. Motion carries. Okay, we have one more finding of fact here we need to move on. Because we have 2 variances.
Right.
Looks like
You're
you're
looking
ready
at
to
me.
go. You said you had to leave early, so
Mr. Chair,
Yeah.
based upon the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted development plan, the findings of fact worksheet, and the presentation by the owner and her representative, I move that this board adopt the following findings of fact, items 1, 2, and 3, and that this application does meet the requirements for granting a variance by demonstrating an unnecessarily hardship on the owner for the following reasons. Sub items A, make sure I got the right one, A through C. I so move.
Thank you, Mr. Hudgens. Do we have a second?
I'll second.
Second by Mr. Kessel. Any further discussion? Okay, all in favor signify by saying aye.
Aye.
All opposed, no. Motion carries. Congratulations. Thank you.
So much, thank you.
Thank you. Okay,
You want the drawing?
yeah, would you like to have your drawings back? Okay, the next item of business on our agenda today are proposed amendments to the current zoning maps regarding properties that are located, I don't know if it's Swan or Black Mountain, but nearby
Very
on
close to
Norfolk
Black
Road.
Mountain.
Yeah. And I think each of you have, of course, we discussed this briefly at our last meeting. The two properties in question were at one time assumed to be zoned by the town, included in and zoned by the town of Black Mountain. Turns out that's not the case. And whereas our county has zoned all the property around these properties, and these two just kind of, for lack of a better term, I think fell through the crack. And Debbie, I'll let you take it from there. I think everybody's aware of the situation here, though.
Yes, they are portions of larger tracts, so that there was just that small piece of two separate parcels that are on the west side of North Fork Road that we assumed were in the town of Black Mountain. The boundary line was incorrect when we were doing that initial zoning in '09. So we're wanting to have those zoned now. I guess we'll take the one that's owned by the state first, and that is PIN 0609248868. And that property is a tract that's over 100 acres. And as I said, just the portion that is west of North Fork Road is in the county's jurisdiction and would be zoned. The proposed zoning for it is PS Public Service, and the land use plan does recommend a zone that would allow for institutional uses in publicly owned properties. And the portion that is within the town of Black Mountain is zoned with a similar type zoning for institutional and office employment type uses. And within that parcel is a state-run health care facility. And
Help me with the process here just a little bit. Has the state of North Carolina been notified of this?
Yes,
Or is-
sir.
okay.
We sent notices to the owner and adjoining property owners, and also within 1,000 feet of the part that's in the county's jurisdiction. We posted a sign on the property and ran the legal ad as well.
Okay, thank you. Does everybody understand this, or do you have any questions regarding this? I'm familiar with the
Yeah,
property.
if you want to know why it happens, I mean, this kind of thing happens when you have to rely on the tax maps to start putting these things together, and it's customary between taxing jurisdictions to put the bulk of the value in one jurisdiction and a minimal de minimis value in the other jurisdiction, so that's why it gets dropped. But zoning and land use regulation can't be treated the same way. So that's why the fix is required.
Okay. This requires a public hearing, does it not? And that's
Yes,
what we're
sir.
here for today.
We have advertised the
Okay.
public
Do we
hearing for
need
today.
we need to hear each one independent of the other, I suspect.
Yes, sir.
Okay. Is there anyone here that would like to speak regarding our intent to zone this property that's currently owned by the state of North Carolina and located on Norfolk Road? Al?
This is your chance.
Yeah. Lord Earl, it appears we have no public comment regarding this matter. So I guess the next order of business is to someone to offer a motion to approve this language and move it forward to the county commissioners for their approval.
So move.
Okay, thank you, Mr. Hudgens.
Glad to help out.
I'll second.
A second. We have a second by Ms. Wood.
And we would want as part of that motion or a separate motion.
Yeah, I mean, it's all written in one motion, but you can say as presented and made available to us, or you can read part of it there. So you have the separate consistency statement and the map.
Move to
change.
approve the resolution of the planning board recommendations as shown on the document and discussed.
Okay.
I want to mention the PIN number.
On PIN number 0609-24-8868.
Okay, thank you. Does your second still
Yeah, I'll still
apply?
second that.
Okay. Any discussion? Okay, hearing none. All in favor signify by saying aye.
Aye.
All opposed, no. Motion carries unanimously. Thank you. The next parcel that is under consideration to be zoned is currently owned by Ingalls Markets. It is adjoining the state property. It's also known as PIN number 0609-14-5017. You want to quickly tell us something, a little bit about that?
The proposed zoning is EMP, and it is Ingalls property. It's adjacent to county EMP zoning, and it is zoned with a like zoning within the town of Black Mountain.
Okay. I'll open the floor again for public comment, if there is any. Apparently there is none, so we'll close the public comment portion of this process. Do I have a motion to approve this resolution for rezoning the property that's currently owned by Ingalls Markets to EMP, not rezone, to zone it to EMP?
Mr. Chairman, I'll make a motion that we accept the resolution and the planning board recommendations and send it to the county board of commissioners. The application for proposed zoning map amendment in reference to PIN number 0609-14-5017 to zone that property EMP.
Okay, thank you, Ms. Wood.
I'll second.
We have a second by Mr. Kessel. Any further discussion? All in favor signify by saying aye. Aye. All opposed, no. Motion carries unanimously. Okay, thank you. Okay, the next item of business on our agenda today has to do with language regarding...
Chairman, I'm going to need to be excused, please.
Okay, thank you for your help. Appreciate it. Language regarding,
Just to clarify for the record, if the board can just by consent let Rod leave, because there is a rule, if someone just bolts and doesn't vote, then it's counted as a yes. So if he's being excused, the board just has to approve that.
So moved.
we have,
I'll second.
okay, any discussion? All in favor signify by saying aye. Aye. All opposed, no.
Oh,
Thank you.
yeah. Aye.
You've been granted your release.
Thank you.
Anyway, the last several meetings we've been talking about language that would create an ordinance that regulated the construction of retaining walls in the county. At our last meeting, it was left such that Vice Chair Kessel and I would meet with staff and try to tweak the language to make it as consistent as possible with what we discussed at our last meeting. We kicked around a lot of things. You know, we focused on the health and safety aspect of this ordinance as well as the aesthetics piece related to this ordinance, proposed ordinance. Last week late, on Thursday, I sent to each of you, I hope that you received it, a copy of the draft that we composed with the help of Debbie and John and, of course, Bernie and I. And I tried to point out therein some revisions that we made. I think the most significant one probably was, and maybe the only significant was, that we were talking about creating an ordinance where the wall height would be, I believe, 15 feet before the, greater than 15 feet before the ordinance became effective. We reduced that threshold down to 10 feet. Now, having said that, and as I said in my email to each of you, the state of North Carolina's building code really requires their ordinance to kick in at 5 feet. I say we, I guess Bernie and I, or maybe just me, felt like that if anything, we needed the engineer involved sooner than later, for the lack of better terminology, in these walls, and that even a wall as shallow in height as 5 feet could present a problem. So we chose 10 for our ordinance, and we wanted to discuss that with you today. I don't know if you've had a chance to read it or not, but we'll go through it with each of you and see if we need to make any additional changes, or we're in a position now to maybe move it on to the county commissioners for their consideration. First of all, did everybody receive my email? Okay. Debbie, if you would quickly go over the changes for us. I hit it briefly, but...
Well, in the first paragraph, it was changed to 10 feet where the regulations become effective. But it was left so that the first terrace is required at 20 feet, and the vegetation and screening is only required at 20 feet. So even though the regulations start at 10, that's for the engineering and safety aspects of it. Just some clarification on the top of the second page, section 78-668. Just that the terracing starts for the height at 20 feet, and the landscaping on B under that starts when it's over 20 feet high and closer than 100 feet to the edge of the road surface. In the planning requirements, that was just an oversight on the draft that we gave you before. We had omitted it and left it at 15, but that was changed to 20 to reflect the vegetation and screening requirements being activated at a 20-foot height. And further in on just past all your planting requirements on C, safety barrier required, there was the requirement added that a guardrail, if there's vehicular traffic within 10 feet of the top of the wall, that a guardrail be installed. And then on section D, just below that, the engineering requirements were changed from 20 to 10 feet.
Okay.
And the very last sentence again, the requirement was changed from 15 to 10.
Okay, thank you.
Can someone explain to me, or just for the record, what cumulative vertical means?
That is the total height. If you're having it broken up with terraces, then that's the total height of all the terraces together.
So if you had 5 and 5 and 5, it'd be 15?
Yeah.
Okay. Thank you.
Okay.
So if I'm reading this correctly, and I hope I am, if we had a series of 15-foot walls, that hypothetically, none of those require vegetation.
Yes.
True statement.
No.
No.
Once it's over 20 feet tall, then
Once
the
the system-
terracing and,
The system is over 20 feet tall.
yes.
Correct.
That was my cumulative question. That would be cumulatively over, as I read it, 20 feet.
Right.
Correct. Yeah.
Is that right?
Yeah,
Okay.
yeah, yeah. Yeah.
And just so this is clear in my head, which I did pull a copy of the building code, their restrictions start at 5, ours start at 10. How much overlap is there here? In other words, does the code require some things that zoning isn't, and vice versa?
The code does require, if you look at D, engineer certification required, the code does require those 1 through 4, but what it doesn't require is that the designing engineer be the one that signs off on that. What it requires now is that it's designed that way, but there's no, it's disjointed. And the building permits department actually had requested that was something they really wanted us to do, was require that the final sign-off was done with
Whoever designed it.
the designer.
So we've got multiple layers of, you've got a third-party verifier and the designer sign off. Is that,
Yes.
okay? Makes sense.
On the table planning requirements, first column at the top, once again, when you say retaining wall height, that means system as well.
Yes.
I'm just wondering if somebody reading that is going to pick up on that. I mean, why wouldn't we just say retaining wall / system height?
Or add cumulative.
The initial definition.
Well, I understand that, but program learning, there's nothing wrong with program learning or a little redundancy for clarification. I'm just trying to be clear. I'm still a little bit troubled by under the second column, minimum required foreground landscaping trees, where we say 1 small deciduous tree and 1 large deciduous tree. What is that? That means different things to different people.
Well, the chart just past that says exactly what those small and large trees are,
Okay,
size
you're right.
and
I
type.
missed that. I've been out of town. Sorry, folks. Good point. I think I'll shut up.
I've got one question. With regard to the guardrail, that wouldn't apply to parking lots, would it?
The guardrail would apply to anything that's, if vehicles are within 10 feet of the
Yeah.
top of the wall.
It would.
Do we need them in the parking lot?
Well, I tell you where I'm thinking of. Back to the Homewood Suites in the back.
Mm-hmm.
Now, I believe there's a guardrail at the top of that wall, at least in that radius, when you go, we're kind of kicking around a job we did years ago together. And I'm pretty certain we put a guardrail there, and that's parking only. Well, it was the travel way, but there's parking places too back there. I know there's parking places back there. Now, where the guardrail terminates, I don't recall. But I think the way it's written, it would definitely apply to both.
Yes, where it came within 10 feet. Now, if they pulled it back further away than 10 feet, then you wouldn't have that requirement.
Yeah, if you pulled it back 10.5 feet, you wouldn't have the requirement. I think when we talked about that the other day, at least in my mind, only in my mind, that we were talking about parking as well as travel ways, in my mind.
Yeah, I didn't even think of it till
Yeah.
just now.
Yeah. And you may have noted, what we had before was strictly a fencing requirement, but we thought about, and I can think of a couple specific examples, one I just gave you, and the other one would be Ingalls on Long Shoals Road in the back. Of course, that's a travel way in the back. That's where tractor-trailer traffic runs. But there's both. There's a fence to keep the people that may meander back there for whatever reason from falling off the wall, and a pedestrian fence, I guess we'd call it, and then there's a guardrail as well. Now, nothing in here would preclude somebody from coming before the board and asking for a variance.
Well, and I saw that in your email, and while I know that's always self-evident that you can always ask for variance, is there any, should we put a sentence in here that encourages that, you know, alternative means for decorative walls are available? Because I think that's something we would all encourage if somebody's
Yeah.
willing to do that.
Yeah, and that's
It's self-evident, but should we?
Well, and that's one of the things I was kind of hung up on too. I mean, again, the stamped walls, the cultured blocks, and things I've brought up before. You know, somebody that wants to spend the extra money, in my opinion, and those walls are very attractive. Of course, it's like a beauty contest, but I think they should be given some type of credit, some relief from the landscaping, obviously,
And I don't
or
think-
you wouldn't do it.
I don't think we can specify it, but should we
No.
put anything in there to encourage it just as a?
I don't know what.
I mean, I know it's always self-evident. I'm just trying to.
Yeah, it is always an option for someone who wants to do something a little bit differently. And when they came to discuss it with staff, we would certainly give them that option.
Okay.
Mhm.
As long as it was pointed out, I just think people should.
Okay. Now, procedurally, what do we need to do? Do we need to
Well-
approve this language?
I did want to discuss that with you. Our legal department has advised us that rather than including it in the zoning ordinance, that it should be a standalone ordinance, in that zoning is really intended for a little bit different. It's buildings and stories and yards and that kind of thing. And when you start mixing structures and buildings together and exempting it from most of the ordinance, it gets things a little bit muddy. So it will be in a different format, and because it is not an amendment to a zoning ordinance, it would not come for a vote or a public hearing with the planning board. It would go straight to the Board of Commissioners.
Okay.
Will you be able to defend a legal challenge as well as it would be if it were zoning?
Well, that's better. That's the point. I mean, if zoning, there's a growing line of cases, and there's a bunch of legislation pending down that's been filed in this session of the General Assembly, which just sort of highlights the political climate we're in. But the line of cases and these new opinion is very strictly, you only have authority to do in zoning what you're specifically authorized by the statute to do in zoning. Clearly, you can look in there and it doesn't say you can regulate retaining walls. But there is structures, so is that iffy or not? I mean, I say let's play with the better card as a police power safety, public safety ordinance as a standalone.
Well, would that require us, again, from the planning board's perspective, do we still need to vote on adopting this language? I guess we do, don't we?
Well, that's what Debbie's saying, and I think the point is you don't have to, but there's nothing that says you can't. You guys have done some good work on this, and if you want to just say, Commissioners, we recommend you pass it, then, I go ahead.
Well, as chair, I think we should. I think the commissioners have put it, don't you, John? John, yeah. I mean, they've looked to us for guidance in this matter, and I think to demonstrate to them clearly where we are on it, I think we maybe should vote the language up or down.
I agree.
You agree? Greg agrees.
This would be like a recommendation.
Exactly.
Is that correct? That would be the formal way that you would move it
Yeah,
forward.
just about like anything else. I mean, they have the right and the purview to
Right.
vote what we recommend up or down. Just happens to be this has to do with retaining walls rather than,
It's just not a formal requirement
Right.
in the process.
Right.
But yes, it would be taken into consideration.
So you can
Okay.
send recommendations up for consideration.
Essentially, yes.
right. Okay, do we have any other discussion regarding this? Well, the chair would entertain a motion to adopt the language that's been presented here this morning, with the exception of what Joe, I think, recommended on page, well, it's 3, although the pages aren't numbered, the first table, where it says retaining wall height. I think we should add the term retaining wall system height. Is that okay, Joe? Does that kind of catch what you want to do? I agree with you, because it could be misinterpreted by lay people anyway. Okay.
I'll make a motion.
Thank you, Craig. We have a second?
I'll second it.
Okay, we have a second by Mr. Kessel. Any further discussion? Okay, hearing none, all signify by saying aye.
Aye.
Aye. All opposed? Motion carries. Thank you. And thanks, everyone, for their consideration and hard work on that. I know the commissioners have, I think, been waiting anxiously for something out of us to move to their purview. The next item on our agenda is public comment. Would anybody from public like to comment today? Please come forward and identify yourself.
I'm Dee Dee Stiles, and one of the things that I noticed about this is there's no maximum height for the retaining wall system. So if you wanted to put in 10 or 15, that's permitted by this regulation. The other thing I see is that no place, not on the steep slope or high elevation overlay, or not on the protected ridge overlay, is there any type of wall, any height of wall system is permitted in any of those places. And I would say that a lot of the residences of our county would prefer not to see extensive terraced wall systems on the tops of our mountains. And I know that the people who are building houses up there, even though for a developer who's trying to build a Walmart or something like that, he doesn't want to spend a significant amount of money and use up a lot of his land. But the people who are building the houses on the tops of the mountains are not so much restricted by, frequently not restricted by the amount of money that they're willing to spend or the amount of land that they're willing to disturb to have what they want. And so I would like to see, at least on the protective ridge overlay, to have the walls be conditional or some limit on the height. Because we have limit on the heights of their houses. And I think to keep it from detracting from the beauty of our county, we need to restrict the heights. This is sort of like locking the door after the horse is gone because you all have just approved this. I understand that. But there isn't a time for public comment before the thing is approved. So I'm saying it now. But I think we need to do a better job of protecting our ridges from people who would build whatever they wanted.
Okay. Thank you, Ms. Stiles. Mr. Guppert, anything? Okay, public comment session is hereby closed. And the next item is adjournment. Do I have a motion to adjourn?
I'll make a motion.
Okay, Mr. Phillips moves. Got a second to? Second. We got a second by Mr. Holmes. Okay, all in favor say aye. Aye. Thank you.